process for First Nations economic development is missing in Canada, a reality that has come under scrutiny from experienced people across the country. The Summit on Aboriginal Economic Development took place May 1st, 08 at the Faculty of Law, University of Toronto, and looked at the Aboriginal economic development including Métis, Inuit, and First Nations. The theme of the summit was Developing Aboriginal Economies. A specific discussion about the commercial law aspect of First Nations life was introduced during the lunchtime address by Ontario Minister of Aboriginal Affairs, the Honourable Michael Bryant. The average Canadian may be nonplussed about the subject of commercial law, but they all live under its massive weight, and Canadians probably realize that most of the law practiced in Canada is commercial law. Unless you are people under the Indian Act, or Indians, those people live under a different set of rules. The Indian Act contains 122 sections devoted to keeping Indians out of commercial law. Just kidding. The Indian Act is about what the people on reserves are able to do, and every single activity on an Indian reserve in Canada has to be decided by the Minister of Indian Affairs, and those 122 sections cast in stone are there to make sure this fact remains. And it all forms the basis of protection of Indian lands. Turns out, the bottom line, what the University of Toronto decided, is that Canadian First Nations need commercial law courts for Indian reserves. Apparently, the Choctaw Tribal Council in the U.S. provides a precedent. It was the Minister Bryant who brought this to the summit table. Here is what the Choctaw have to say about jurisdiction over housing and other buildings on reserve. Under Choctaw's constitution, jurisdiction is extended over all person or entities within the jurisdiction of the tribe who sell, rent, lease, or allow persons to occupy housing dwellings or accommodation for the purpose of human dwelling, occupation, or residence, and all persons who buy, rent, lease, or occupy such structures. The Choctaw Constitution continues, such personal jurisdiction is extended over all persons and entities, whether or not they are members of the tribe, whether they are Indian or non-Indian, and whether they have a place of business within the Choctaw Indian Reservation. Any act within the reservation dealing with the subject matter of this title shall be subject to the jurisdiction of the tribe. It all sounds really legal. And here's why. Because jurisdiction on Choctaw land is enforced. Quote, jurisdiction over all matters arising within the jurisdiction of the tribe with respect to the subjects of this title, and jurisdiction with respect to any person or entity acting or causing actions which are within this title shall be exercised by the Tribal Court of the Mississippi Band of Choctaw Indians. Tribal Court. Canadian First Nations are not there. Nevertheless, quote, there are all sorts of very good working relationships that are already developed, unquote, said Chief Glenn Nolan the previous month, April 18th, 08, to the Canadian Institute of Mining, Metallurgy and Petroleum, Sudbury Branch, General Membership Meeting. The chief of the Missinaibi Cree First Nation told the meeting of miners, what I'm trying to do is show that we're willing partners out here, that mining companies need to build relationships with Aboriginal communities in order for future projects to work.